And can you explain the difference between reasonable suspicion and probable cause?
No, I'm not going to get into that. You know, there are all kinds of facts and circumstances that officers encounter on the street, and judges and lawyers will be sorting through what's probable cause and what's reasonable suspicion for years. But generally speaking, I've explained probable cause many, many times, of course. It's that those facts or circumstances that would lead a reasonable person to believe the person is probably guilty or not guilty. Dan's question is guilty of immigration violation or guilty of, or in the reasonable suspicion standpoint, is it reasonable suspicion to believe that it's an immigration violation?
No, what I mean is I have reasonable suspicion that Dan Gens is speeding. Then in that check of the speeding, I have probable cause that Dan Gens is an illegal immigrant. That's what I think the difference is. But anyway. Well,
it's really difficult to get into individual scenarios about what if. But I think a clear example of how officers would be authorized to inquire about the immigration status of someone before the person is physically arrested. We are all clear, I would assume by now, that if someone is physically arrested, immigration status checks would be done in all cases. We're talking about what happens prior to that. The example I was trying to explain is if there's a question, if an officer has someone has a legitimate inquiry, has a detention or whatever the case might be, and believes that there is a question about the person's true identity. They may think they have a false name. They may believe that they don't have the correct name, and they have reasonable suspicion, as is in here, to believe that they are not here lawfully. That they certainly would be likely to run an immigration status check.
Does that represent a major change in policy?
No. Pretty much like it was before. The difference was before it was a mandate, and probable cause was part of it.
Who and how long, Chief, will train officers to implement this policy? You said the target date was the end of June.
Yes,
Can you tell us a little bit about the training officers?
Thank you, Bernard. I'd be glad to do that. It'll be our staff, generally, and the county attorney, but we're thinking a couple of hours or less, aren't we?
Probably be about an hour at roll call.
Step over.
An hour at roll call?
Probably be about an hour, give or take, at roll call training, and we have squad days, which is our days that offer training opportunities to officers. We'll conduct some of it at roll call, some of it at squad days, and that training will most likely be conducted by myself and other command staff and other commanders who have previously served as trainers in the immigration topic. We'll train them up, and they've already seen the policy. They're very familiar with it. You know, we know a lot more than we did in January about how this program works. So it doesn't take as much training activity to train the officers up with this change.
But you've worked previously in immigration detention. Is that right? I'm sorry.
All of the officers on the previous policy had extensive training before we implemented it in early March. So they're very familiar with the policy that we had in terms of the probable cause and the general order. So this is a change that will not take them long to grasp. And probably about an hour, give or take, either way, will be sufficient to train them up on the new policy. And as I say, that'll be conducted by myself and other commanders in the police department.
And it takes effect when?
It'll take effect when the training is done, as the chief mentioned, probably be toward the end of this month.
Chief, I'm not trying to put you on the spot with this, but we have two vastly different characterizations of this in the public arena right now. And you are the top law enforcement official. Do you disagree with the characterization that the First Amendment is a dramatic change, a significant change in policy?
First Amendment, what do you mean? This
With the reasonable
resolution?
suspicion standard prior to arrest, that an officer may, if he or she has reasonable suspicion, look into immigration status. The chairman is characterizing that as a major, significant change that will result in far more people being questioned. You say it is not. Is that characterization wrong? I think the public needs to understand.
Well, I can only answer the question in a different way. And the way I would say it is that we anticipate carrying out this resolution, very similar to the other resolution, but the mandatory portion of this has now changed to after arrest, when someone's physically arrested. So we're clear on that. And the prior to physical arrest, I don't anticipate more inquiries than I certainly don't anticipate more inquiries than we had conducted in the past.
We were also told that this is going to be much cheaper than the other way. Do you agree with that?
Well, you know, the resolution, part of the wording in the resolution that made the change had language in it that dealt with the issue of possibly avoiding the need for cameras, because part of the motive of the change was to reduce potential liability and claims of racial profiling or whatever. So from that perspective, cost was part of the decision to get to where we are today, as to how much it will cost to actually implement, and the time we'll be spending on it, et cetera. I can't comment on that. I don't know. Okay. We need more experience to determine exact how much time it's going to take us to do these processings and things. But from the one perspective, it is less expensive.
Chief, if I remember correctly, the cameras and the patrol cars was not included in the budget, correct?
Correct.
And that's part, and you're telling us now that's part of the motivation for the change in policy?
That's what's in the resolution, yes.
Do you feel that your officers are protected adequately from charges of racial profiling with this amendment as it stands right now?
I think having it at the arrest stage certainly reduces the potential for successful claims. I was confident that the previous method was lawful, and that we were going to do it as good as we could. But certainly, my view was it was high risk, and that's why I asked for the cameras. And of course, I also recognize the fiscal reality is cameras, and the support that needs to go with the cameras is very expensive. But I saw it as something that was a pretty essential need if we're going to get into this new realm of responsibility.
One other follow-up question on it. If you felt like that mandating it at the arrest stage, mandating at that point, lowers that risk, why then is the may inquire prior to important? Why do you need that early part when it's mandated after an arrest?
Well, that's just good police work. You can imagine from the scenario I gave you that it would be ludicrous for us not to allow or to expect officers not to do inquiries if they thought someone was playing games with them, give them a false name or something like that. It's just simply good police work. So we don't want to be prohibiting officers from making inquiries when it's in the best interest of the community. But that does not say that we're mandating officers to do those kinds of inquiries at that stage. That does not happen. It's not part of it.
I don't want to be a jerk, but if this is such a great policy, why wasn't it written this way in the first place instead of training everybody and then going back and amending it and then having to retrain everybody?
You're asking the wrong people.